The European Union's new AI Act is, well, it's massive. It's a huge piece of legislation. But today, we're going to zoom in on one small but absolutely critical part that often gets overlooked: the safety net for when AI goes wrong. We'll be exploring the protections for whistleblowers, and this analysis is based on work carried out under the scientific supervision of Professor Vihar Kiskinov.
So let's start with a really important question. When a powerful and complex AI system goes off the rails, when it's biased or unsafe or just plain breaks the rules, how do we find out? Who's the person on the inside with the courage to sound the alarm?
The answer lies in a mechanism that you can really think of as the emergency stop button for AI. Now, this isn't a technical switch we're talking about. It's a human one, the whistleblower. They are an absolutely crucial safety mechanism, not just for a company, but for all of us, for society, especially when we're dealing with powerful new technologies like this. And this emergency stop button isn't just a nice idea or a metaphor. It's a real core component of the EU's AI Act. It is a legal safety net, and it's designed to catch the kinds of problems that formal checks and balances might miss. So let's break down how it actually works. The entire system really hinges on one single short provision, Article 87. And here's the brilliant part. Instead of creating some brand new complicated system just for AI, it does something way simpler, and you could argue much more powerful. It just connects the entire AI Act to the EU's existing Whistleblowing Directive.
So you might be wondering, how did lawmakers land on such an elegant and simple solution? To really get the thinking behind it, we need to look at the history of how this short but really vital article was put together. When you look at the drafting history, something pretty remarkable stands out. From the very first proposal by the European Parliament all the way to the final text, the core of Article 87 just didn't change. And that wasn't an accident. It was a very deliberate, minimalist approach by the lawmakers. In fact, this quote from the source material just says it all. The lawmakers made a conscious choice to rely on a framework that was already proven, that already existed, rather than reinventing the wheel specifically for AI. That consistency shows there was a really strong agreement that the general shield for whistleblowers was the right tool for the job.
Okay, so we have this shield. The big question is, what does that shield actually do for you? What kind of real-world protection does a person get when they decide to hit that emergency stop button and report a problem with the AI Act? By linking up with that existing whistleblowing directive, Article 87 gives you 3 core protections. First up, you can report in confidence. Authorities are legally required to protect who you are. Second, and this is huge, you are protected from retaliation. That means it's illegal for your employer to fire you, demote you, or punish you in any way for speaking up. And third, if retaliation does happen, the framework gives you access to support and legal remedies, which can even include compensation. Now, it's really important we don't get this confused with another tool in the AI Act. Whistleblowing, under Article 87, is all about exposing a problem that's in the public interest, like a flawed system that could affect a lot of people. A complaint, which is covered by Article 85, is different. That's about addressing a specific personal harm that you've suffered and trying to get things made right for you. So one is about fixing the whole system, the other is about fixing a personal issue. So let's make this real. What kind of situations are we actually talking about here? Well, imagine a data scientist who discovers their company's hiring algorithm is systematically biased against a certain group of people. Or a doctor who realizes a new diagnostic AI is consistently making dangerous errors for a specific type of patient. Or maybe an engineer who sees that a powerful AI model is being used to amplify hate speech. These are exactly the kinds of big, systemic, public interest issues that Article 87 is there for.
All right, so far this might seem pretty straightforward, right? But Article 87 doesn't live in a bubble. It's actually the central thread in a much bigger, much more complex web of EU rules that govern our entire digital world.
Just think about it for a second. A whistleblower reports a biased AI, and boom, that could also be a data privacy violation under GDPR. Or a report about an unsafe AI could kick off an investigation under the Digital Services Act. Article 87 acts like this crucial bridge, connecting a single report to this whole ecosystem of digital rules.
But, and this is a big but, this simple minimalist approach isn't perfect. It has a major challenge. The protection explicitly covers the reporting of concrete infringements. But what about the near misses? Or what about serious ethical concerns that aren't quite a clear violation of the law, Yet, by focusing only on proven breaches, the law might accidentally create a chilling effect, where people are afraid to report serious risks before they turn into full-blown disasters. And that really leaves us with the central question as we move forward. The EU has chosen a general, all-purpose shield to protect those who sound the alarm on AI. But as this technology gets more powerful and, frankly, more unpredictable, we have to ask ourselves, is that general shield strong enough for the very specific and totally new dangers that artificial intelligence presents?